Hello, everyone. My name is Farouk Abbas, and I want to give you 4 tips you should keep in mind when acquiring properties from the administrators of an estate. Who are administrators of an estate? Administrators are those whom the law have given the power to take over the assets belonging to a deceased person who died without a will. And these administrators are those who can transfer the properties to a buyer who is interested in buying those properties. And what usually happens is the probate registry usually issues a document called letters of administration to the administrators. So the first tip I want you to keep in mind when acquiring a properties from administrators of an estate is that you must ensure that the property you want to buy is listed in the letters of administration. Because we've seen cases where a deceased passed away and he owned 5 properties, but when his administrators applied for the letters of administration, they will only include the property in the letters of administration. And where the property is not included in the letters of administration, what it simply means is that the administrators cannot legally transfer that property to you. So where you have a situation where the property is not listed in letter of administration, you must tell the administrators to take administrative steps to include the property in the letter of administration. So tip number one is ensure that the property you want to acquire is listed in the letter of administration. Tip number two is that you ensure that all the administrators are available and willing to sign the transfer documents of the property to you. Because normally what we have is we have a maximum of 4 administrators, and we've seen situations where out of these 4 administrators, maybe only 2 administrators want to sell the property to you. In this sort of situation, you must tell the administrators to come together, meet with them, confirm their identities, and confirm they are willing to sell. If the administrators tell you that there are 4 of them, but only 2 of them are available to sign, then you must ensure that the entire 4 of the administrators sign a resolution authorizing the sale of the property to you, and also stating that out of the 4 of us, only 2 of us will sign the transfer document. And this point is very important because we've had cases, including at the Supreme Court, where the Supreme Court nullified the sale of a property by administrators to an individual because the transfer documents were not signed by all the administrators. So if you have 4 administrators, the entire 4 administrators must sign. If the 4 of them can't sign, then they must do a resolution authorizing 2 or 3 or any other number to sign on their behalf. So that's tip number two. And tip number three is that when you want to make payment for the purchase of a property from the administrator of an estate, you must ensure that you make the payment directly into the estate account. All administrators of estates have an estate account, and they are usually all signatories to the account. And no administrator can withdraw money from that account without the concurrence of the other administrators. But of course, we usually have situations where the administrators will tell you that for one reason or the other, they don't want you to make the payment into the estate account. They want you to make the payment into another nominated account. In this sort of situation, before you make that kind of payment, you must ensure that the administrators issue a resolution authorizing you to transfer the payment into the nominated account. You must also ensure that your transfer documents include a clause stating that they've authorized you to make the payment into that account. Because if you pay the money belonging to the estate into an individual administrator's account or into another account, in the future, either the beneficiaries or the other administrators can come together and say that they never sold the property to you, because payment for the consideration is one of the requirements for a valid contract. So if you don't pay the consideration into the right account, then the sale can be nullified on that ground. And the last tip I want to give you is that we have situations where some people who want to buy properties are discussing with the children of the deceased or the beneficiaries. In this sort of situation, don't place too much reliance on any information you get from the beneficiaries or from the children, because when you are buying properties from the administrators are usually superior to the children. But we also have situations where the children are also the administrators. In that sort of situation, you'll be in safe hands. So I've given you 4 tips, and I hope that you comply with these 4 tips whenever you want to enter into a transaction with the administrators of an estate. Because these 4 tips I've given you are gotten from my experience over the past 15 years in representing buyers who buy property from all form of sellers, including administrators of estate. And I believe that once you comply with these tips, you are going to have a very smooth and sound transaction. Thank you very much.